Assalamualaikum warahmatullahi wabarakatuh, and a very good day. Today, my group, which consists of me, HUDA, and SYAKIRAH, will be presenting on the problem statement alongside with the solution, which will be discussed under the topic of Occupiers liability. Hope you enjoy the presentation. Here are the table of content. First, we will discuss on the problem statement from the news. Second, the summary and analysis of case laws relating to the problem statement. Third, a summary of journal article. And lastly, the group legal analysis.
For this case study, we have chosen the case under Occupiers liability at the newspaper, which date on 11 November 2021, which is about one man dies and the other one was injured after falling off a Ferris wheel in Cheras. What actually happened here? So let's watch the news of this case with us.
When asked whether or not the fun fair had proper permits, Kajang OCPD Assistant Commissioner Muhammad Zaid Hassan said the case is still being investigated. On Thursday, a 39-year-old man died and another was injured after falling off a Ferris wheel at the fun fair near a mall in Cheras Selatan. Police discovered no criminal elements in the incident but were still trying to determine if the fall was a result of negligence by the fun fair operators or the victims themselves. The incident has been classified as sudden death.
After watching this news, we have come to provide some of the problem statements of this case. There will be 5 problem statements that we have analyzed. First, whether the disease is considered as an invitee in the theme park and therefore should get a safe environment provided by the management under Occupiers liability. Second, whether falling from a Ferris wheel is considered an unusual danger. Third, whether the management of the theme park knows of the danger that might happen if they did not provide a safe environment. Fourth, whether the two men do not know that using the premise will give them some form of danger. 5, whether the management failed to take reasonable care to prevent danger by giving notice about any possible dangers on all of its rights.
Next is the summary and analysis of case laws relating to the problem statement. The first case is the case of Raja Niponan and Perbadanan Pengurusan Terminal 1 reported in 2021. First, I will explain on the facts of the case. The appellant in this case appealed against the dismissal of his claim before the session court. The fact is that the respondent defendant operated a shopping center. It had engaged a contractor named Govin to undertake certain electrical work at its premise. Govin was not, however, appropriately qualified to undertake the works. He then correctly engaged a qualified electrician, Annamalai, to undertake certain cable joining works. The plaintiff, which is the appellant before this court, was an employee of Annamalai. He suffered an electric shock while undertaking works on the premise, for which he claimed that the defendant was liable. But the session court dismissed the claim, holding that the contention of breach of duty of care had not been made out in this judgment. The parties are referred to refer as they were before the session court. Next, for the decision, as a result, the appeal was dismissed with cause. It is because the duty of care did not exist in the first place. Therefore, it was not necessary to analyze the judgment of the session court, which ruled that there had been no breach of such duty. Moving to the ratio decidendi, first, the court refers to the case of Mohamad Sarpi and Soil Built Pte. Limited 1996, where the decisions of the Singapore Court of Appeal, where the plaintiff claimed against the defendants for inter alia breach of duties of occupiers of the site. The plaintiff, who had been engaged to install a sprinkler system in a warehouse, fell 4 stories from a modified scaffolding. He was not wearing safety apparatus at the time. In that case, it was held that a person who appoints an independent contractor does not, ipso facto, absolve himself of liability and negligence to the employees of his independent contractors. However, he may still be liable if the working conditions are inherently dangerous, thereby requiring the exercise of a significant degree of control over a person with whom he has no contractual relationship, or he had taken upon himself to exercise control over and actively coordinate the independent contractor's activities. The Singapore Court of Appeal then held that an occupier merely owed a duty to persons lawfully on the premises to use reasonable care to prevent damage from unusual dangers which the occupier knew or ought to know about. Next, the judge in the present case was in a view that as the plaintiff cause of action was grounded upon a duty that was said to be owed to him by the defendant or occupier of the premises. In the present case, the plaintiff in the present instance was not an employee of the independent contractor engaged by the respondent. He was in fact an employee of the independent subcontractor engaged by the defendant's independent contractor. On the facts of the present case, there was no unusual danger present in the premises that outside of the realm of the experience or expertise of the plaintiff, whom it will be recalled is a duly certified electrical technician. The defendant engaged an electrical technician to undertake the job precisely because the job required a duly qualified technician. Turned out that Govin, who was engaged by the defendant, did not possess the necessary certification to undertake the works, and as a consequence, Govin engaged someone who did. When someone is engaged to undertake a job that requires certification to undertake, one can reasonably expect that a duly certified and qualified person will be best placed to assess the risks that may potentially arise from the works to be undertaken. And lastly, put it another way, the relationship between the parties that of an occupier of the premises and the employee of an independent subcontractor, which whom the occupier had no contractual nexus, was not sufficiently approximate as to give rise to a duty of care. Even if it was, it would not be fair, just and reasonable to impose a duty of care because the defendant had done all that a reasonably prudent person could have done in the circumstances, which was to engage an electrician. When the electrician engaged another electrician, it would not be reasonable to impose a duty on the defendant to police or supervise the selection of the subcontractor. The defendant was entitled to assume that whomever was appointed possessed the necessary qualifications. In any event, the plaintiff was better placed than the defendant to assess the risks associated with the job and ought to have taken the necessary precaution in order to eliminate or mitigate such risks.
Now, we will discuss the second case, which is Shanta anak perempuan Malikam and Tek Ju Chan Sdn Bhd and another in the year of 2015. First, we will go to the summary of this case. Lachmanan anak lelaki Subramaniam, the deceased, was employed as a lorry driver by Tek Ju Chan Sdn Bhd, which is the first defendant. On 23rd April 2009, the deceased and his lorry attendant Morgan anak lelaki Ramasamy were instructed by the first defendant to go to the second defendant's premises, which is Westport Malaysia Sdn Bhd, located in Port Klang, to collect a shipment of corn. The deceased was issued a security pass by the second defendant to enter its premises for this purpose. At about 11 am, the deceased and his attendant completed the task of loading the corn onto the lorry. Whilst the deceased was fixing the chain to the exterior of his lorry, he was knocked down by an excavator driven by Tan Chun Wat. The deceased was rushed to hospital but was pronounced dead on arrival. On the same day, Yap Jian Min, the manager of Westport Warehouse Services in Bhd, lodged a police report stating that their employee Tan Chun Wat had informed him that about the incident. Terdapat seorang pemandu lori BAE 4383 telah pengsan semasa kerja memunggah jagung ke dalam lori di dalam gudang. It does mention that there was the mention in the report that Tan Chun Wat was the excavator driver who had knocked down the deceased. An inquiry was conducted by the second defendant sometime in 2009 as regards this mishap. However, the report was not produced in court. Now, we will discuss the decision of this case. The sessions judge accepted the primary submission made on behalf of the second defendant and dismissed the claim. She found contrary to her earlier finding in the striking out application that the plaintiff was aware of the identity of the excavator driver and the failure to cite him as an co-defendant was fatal. It is implicit from her decision that she took the view that the averment pleaded in the claim indicated the action was based on vicarious liability and not Occupier's liability. The sessions judge also went to make finding of fact that although the second defendant had control of the security and maintenance of the site, it was not the occupier. The occupier was C. Hoi Chan Agency Sdn Bhd by virtue of the lease agreement between the second defendant and C. Hoi Chan Agency Sdn Bhd. Now we go to the ratio. In April 2012, the plaintiff, as the lawful wife of the deceased, commenced proceedings for the damages under Section 7 of the Civil Law Act 1956 against the first and second defendants for herself and her children being the dependents. It was alleged inter alia that it did not own and had no control of the site where the accident took place, as the same had been leased to C. Hoi Chan Agency Sdn Bhd, and that the excavator driver was not its employee. The excavator driver was the employee of a company known as Westport Warehouse Services Sdn Bhd that had been engaged by C. Hoi Chan Agencies Sdn Bhd to handle cargo handling operations. In March 2013, the second defendant applied under Section 18 and 19 of the Rules of Court 2012 to strike out the plaintiff's claim on the ground that the action was unsustainable on the basis that the plaintiff had failed to cite the excavator driver as a co-defendant, despite having in possession his personal particulars. The second defendant argued that it could not be held liable vicariously in tort unless the excavator driver, the person responsible for the alleged tortious act, was named as a co-defendant and shown to be its agent, servant, or employee. On 10 June 2013, the application was dismissed by the trial judge. She found that the plaintiff had only secured his particulars after the limitation period had set in, when this information was disclosed to her by the second defendant's solicitors already. On 10 Jan 2013, the plaintiff withdrew her claim against the first defendant, and the trial proceeded against the second defendant. A total of 7 witnesses were called, including Morgan, the lawyer attendant. At the close of the case, the plaintiff contended that the second defendant was liable for breach of duty to provide a safe system of work as the occupier of the site. The omission to cite the excavator driver as a defendant was not fatal, as the plaintiff claim was premised on occupier's liability. The second defendant disputed that the plaintiff's cause of action was based on occupier's liability. The second defendant contended that it was plain from a reading of the statement of claim that the cause of action was based on vicarious liability, though the term was not expressly used. It was pointed out that the term occupier's liability was not mentioned in the statement of claim. Alternatively, it was argued that the claim based on occupier's liability must fail on the ground that the second defendant was neither in occupation nor in control of the site which had been leased to C. Hoi Chan Services Sdn Bhd at the material time, as C. Hoi Chan Services Sdn Bhd was the occupier.
Okay, so the next part of our presentation for today, we will give the summary of the journal article that we have chosen. Okay, so the title of our journal article is Uplifting the Standard of Duty of Care Towards Guests, an overview of recent developments in selected countries. So under the common law, the standard of duty of care differs from a contractual entrant, invitee, and licensee, although these different groups of entrants are legal entrants too. The contractual entrants are divided into 2 categories, which is the main purpose entrant and ancillary purpose entrant. As for the main purpose entrant, an occupier has a duty to ensure that the premise is safe for the purposes of the contract, as reasonable care and skill on the part of anyone can make them. Meanwhile, for the ancillary purpose entrant, on the other hand, an occupier has a duty to ensure that the premises are reasonably safe in all respects respects for the objectives for which the other party was invited to use them. Invitees are also divided into two categories, and they are the legally authorized entrants and business visitors. However, the occupier owes the same duty of care to both these categories of invitees. The duty of care for the occupier is that they have to take reasonable care to prevent damage from unusual danger, of which the occupier knows or ought to know of, and which the entrant does not know. The characteristic feature of a contractual entrant is that an entry is made lawful or permitted by the contract itself, and not, for example, by virtue of conferring a business benefit on the occupier, as in the case of an invitee, or by virtue of the occupier's express or implied permission, as in the case of a licensee. The article compared the approach of applying liability between Malaysia and other countries such as Australia, Britain, United States, and New Zealand. Malaysia courts, in this case, are still recognizing the common law different categorization of duty of care. So, for example, we can look at the case of Datuk Bandar Dewan Bandaraya and Ong Kok Ping and another 1999, where the court held that the liability of occupiers depends on the character in which people have entered the premise. The court illustrates the different categories of entrance in a premise. Firstly, people who enter the premise by virtue of a contract, such as a guest in a hotel. Secondly, people who enter the premise on business of interest, both to such persons as well as the occupiers. For example, a customer who goes to shop to view the goods. Thirdly, person who enter the premise with the express or implied permission of the occupiers without neither a contract, no such community of interest. This kind of person are called licensees. And fourthly, the court also determined persons who enter as trespassers. In this case, the Supreme Court relied on pre-1957 cases where the common law as regards the liability of the occupier or owner of dangerous premises, including land, buildings and structures, still applies wholly to Malaysia. So hence, such an approach would maintain the traditional problematic issue of distinction between the different types of entrance that happen in Malaysia. So compare what happened in this case with the two-stage approach, which has sufficient relationship of proximity based on foreseeability and assessments of reasons why there should not be a duty of care for evaluating the existence of a duty of care that has been rejected by Australian and British courts. While compared nation courts and the United States, where in the United States the courts have held that the status of entrant is not a determinant factor of the duty of care, whereby the common law rule was replaced by one uniform test, which has proven to be effective in other areas of negligence law. And lastly, we compare Malaysia to New Zealand, where in New Zealand, decided cases have proven that courts broaden the concept of duty of care from category by category approach, just like Malaysia, to a general rule of liability based upon foreseeability of injury to one's neighbour. Next, the article also discussed on how to determine liability using the case of Donahue and Stevenson in 1932. The pure Donahue and Stevenson principle is a principle that integrates standard negligence considerations regulating so-called physical loss, which, for example, harm to person or property, in establishing the occupier's obligation. In Donahue and Stevenson, there were two key elements to the neighbour principle test. First, a duty would exist where an injury was reasonably foreseeable. Secondly, the relationship between the person who owed the duty and the person to whom it was owed had to be such that the latter was likely to be so closely and directly affected by the former's activities and so could reasonably have them in contemplation. So in conclusion, England, for example, had abolished the licensee-invitee distinction through the enactment of the Occupiers Liability Act 1957. Specifically, Section 2 of the Act substituted a singular duty of care owed to all lawful visitors in place of the common law duties owed to an invitee and licensee, which had resolved all the problematic issues of differentiation between the different categories of entrance into a promise, just like what happened in Malaysia. However, in Malaysia, due to the non-existence of a specific Occupiers Liability Act, it is hard to identify the status of contractual entrant, licensee, or invitee. All for the summary of the article journal that we have chosen.
From the case of the Ferris wheel and the occupier's liability, we have come with analysis in terms of legal discussion. For the first main issue is whether the disease is considered as an invitee in a funfair and therefore should get a safe environment provided by the management and the occupier's liability. The rule is, first and foremost, we should know what is actually the occupier's liability. Occupier's liability is the duty of care owed by occupiers of premises toward visitors, whether invited or invited, who suffers either personal injury or property damage during the course of their visits. According to Lord Denny in Wheat and Lacan and Corporation Limited 1966, occupier is a person who has sufficient degree of control over premises to put him under a duty of care towards those who came lawfully on the premises. Two or more may be occupied as in China Insurance Corporation Limited and who PTE Limited in applying the contract test as laid down in Wheat and Lacan held that the contractor of a construction site was an occupier of the premises. Occupier need not have exclusive occupation as in Lembaga Kemajuan Tanah, Persekutuan and Mariam, where the court held that the defendant did not cease to be in possession and continued to be occupier of the site as the Consi house which collapsed on the disease was built for the common benefit of the defendant, contractors and the labourers. In Lautin Share and Yusuf bin Muhammad 1973, premise is defined as all forms of buildings, land spaces, vehicles to carry persons including tractors. This means that premises are fixed or movable structures. According to Peh Swee Chin in Datuk Bandar, Dewan Bandaraya Kuala Lumpur, and Ong Kok Peng and another, there are 4 types of entrance with descending degree duty of care, where the highest degree of care is owed to contractual entrance, followed by invitees, licenses, and lastly trespassers. So in this case, we will apply the invitees type as the entrance. Invitee is a person who enters the premises of the occupier with his consent in the pursuit of a common interest with the occupier. There are 2 types of invitees. First is a legal authorized entrant who enters the premises as a matter of law. Second is a business visitor or associate who enters the premises where it is public or private. An invitee is therefore invited onto the premises usually for business purposes. The duty of an occupier to an invitee is stated by wise in Adamar and Dams is the occupier shall use reasonable care to prevent damage from unusual danger which he knows or ought to know. Applying the law to the current case, the occupier is management of the funfair as they are the owner of the funfair and have sufficient degree of control over the premise. Meanwhile, the premise of the Ferris wheel's funfair, for this situation, in specifying the category of visitor, the 2 men will fall under the category of business invitee as they are the person who enters premises with the permission of the occupier for the purpose of carrying on the particular business, which is for visiting the funfair and will bring economic advantage to the management of funfair. As a reasonable man, management of the funfair knew or ought to have known about the danger and risk if they did not provide the protective measures to the customer. So here we can make the assumption that the management of the funfair did not provide the necessary precautions for the Ferris wheel to be safe for the people to ride it. It is because as a reasonable man, one of the men will not fall from the Ferris wheel if precautions had been taken by the management, as assuming here maybe the management did not explain the rules to the visitors before riding, or maybe the Ferris wheel has no proper safety measures provided. In conclusion, the men will fall under the category of business invitee as they are the person who enters premises with the permission of the occupier for the purpose of carrying on the particular business. So it can be proven here that the management of funfair owed responsibility to provide a safe environment to the visitors under occupier's liability. Okay, now we will move to the sub-issue 1, whether falling from a Ferris wheel is considered an unusual danger. So the rule is that the first requirement that needs to be proven in order to make the occupier, in this case the management of the funfair, to be liable is that the danger must be unusual, one to the invitee, which is in this case are the 2 men. In the case of Indomar Dams, court held that the danger was unusual, which was known to the defendant, and even though the plaintiff, as an invitee, has to take reasonable care of his own safety, an occupier must reasonably avoid any damage that could arise from an extraordinary danger that is known or ought to have been known to him. For my understanding about this matter, the meaning of unusual danger can be referred to in the case of London Driving Dog Corporation Limited and Horton 1951. Similarly to the case of Takon Tabari and Government of Sarawak 1996, where the disease was making banking transactions in the premises of a public bank in Miri when inflammable gas escaped, ignited and causes a series of explosions and fire. Then the court held that the bank was liable because an explosion was unusual danger in a bank which was usually believed to be safe and secure place. To be more relevant, we can measure if through the objective test. Actually, unusual danger depends on the type of plaintiff, circumstances surrounding the premises, and plaintiff's knowledge. For example, in the case of Christmas and General Cleaning Contractors 1951, now move to the meaning of occupier's knowledge. An occupier will be liable for any danger that is known or ought to have been known by him as a reasonable man. We can see the case of Hawkins and Costan and Pearl UDC 1954 states if the occupier knows of the physical condition of the premise and a reasonable man would know that it is dangerous, the occupier is deemed to know of the danger, he owes a duty to warn an invitee unless the danger is obvious. Additionally, the state of knowledge at the time is also taken into account to determine whether the danger ought to have been known by the occupier. For the knowledge of the plaintiff, if the plaintiff knows the existence of the danger is not unusual. So defendant will not be held liable if the plaintiff completely and truly knows of the nature and extent of the danger. Now, we will move to the application for this case. First thing first, we must analyze whether the danger is unusual to the man. Even though the plaintiff as an invitee has to take reasonable care for his own safety, an occupier must reasonably avoid any damage that could arise from his an extraordinary danger that is known to him in the sense that the danger is not usually found in carrying out their enjoyment. Actually, unusual danger depends on the 2 men, circumstances surrounding the Ferris wheel, and the 2 men's knowledge. From the facts of this case, there was no mention about the safety measurement, so here we can make the assumption that a Ferris wheel is considered safe and reasonable for the management of funfair is not an unusual danger for them, but is unusual for visitors that ride the Ferris wheel to believe that environment are unsafe. Therefore, they could not reasonably foresee the danger while they were riding the Ferris wheel. However, by looking at the circumstances surrounding the premises, where there were attraction to the people, the 2 men can be assumed to have known about the risk of not following the rules that had been provided by the management of funfair. As the 2 men took action to make sure they were not in the risk situation, the management of funfair, however, failed to reasonably avoid the danger as there was insufficient protection provided. The assumption that we want to use here is that if the management of a funfair really does their job to avoid the death of one of the men, they will make the measurements of precautions as the priority. Either the 2 men or any person would not have expected and thought the death would happen by falling from the Ferris wheel, since the funfair is a public amusement park. Then everyone assumes that the vicinity is safe to accommodate the public. To conclude, falling from a Ferris wheel is considered an unusual danger. Prior to the knowledge as a reasonable man, this danger does not really happen in the public, since the occupiers will make sure the precautions of safety have been taken. Besides, the man did not expect and thought the death would happen by falling from the Ferris wheel, since the funfair is a public amusement park, which everyone assumes that the vicinity is safe to accommodate the public.
Moving to the second sub-issue, whether the management knows of the danger that might happen if they did not provide a safe environment. So, the next requirement that needs to be proven is the occupier knows or ought to know of the danger. An occupier is liable for any danger that is actually known to or ought to be known by him as a reasonable man. It is because the occupier has a duty to ensure the safety of the premises for the purpose for which the invitee remains on it. In Hawkins and Colston and Purely UDC 1954, Lord Dunning stated that if the occupier knows of the physical condition of the premises and a reasonable man would know that it is dangerous, then the occupier is deemed to know of the danger. He has a duty to warn an invitee unless the danger is obvious. In assessing whether the danger ought to have been known to the occupier, the state of knowledge at the time is taken into account. Applying the precedent case in the situation of the two men who had fallen off a Ferris wheel in Cheras that day, the management of the funfair should know of the danger that might happen if they did not provide a safe environment. It is because the possibility of danger to arise is very high. The management of the funfair has a duty to ensure that all customers who rode the Ferris wheel were guaranteed safety. If the management of the funfair knows of the danger or risks of the Ferris wheel at the time, then the management is deemed to know of the danger. Also, they have a duty to warn the customer or the invitee at the time by not riding the Ferris wheel or better close it. So for conclusion, therefore, the management of the funfair should be held liable as an occupier if the danger that happened to the two men is likely to happen because their part did not ensure their premises be in a safe condition. Next, for the third sub-issue, whether the two men do not know that using the premise will give them some form of danger. The third requirement is the danger is not known to the entrant. The meaning of unusual danger has been elaborated in the case of London Graving Dog Company and Horton 1951. The House of Lords held that an unusual and extraordinary danger or risk is one which is not common for the purpose of a particular invitee. Therefore, unusual danger depends on the type of plaintiff, the circumstances surrounding the premises, and also the plaintiff's knowledge. If the plaintiff knows of the existence of the danger, then the danger ceases to be an unusual danger. As in this case, where a welder whose claim for injuries sustained due to defective staging by the occupier was denied, as he was held to be aware of the danger. In the English case of Stowell and the Railway Executive 1949, the court held that a puddle of oil at a railway station was held to be an unusual danger to the plaintiff invitee who was waiting for his friend, while in the case of Christmas and General Cleaning Contractors 1951, a broken and dangerous window was held not to be an unusual for a window cleaner, although the plaintiff was able to recover from his employers for failing to provide safety equipment while he performed his job. Another case that can be referred to is the case of Lilau and Sons Realty Sendian Berhad and Tanya and others 1983. The court held that the danger that was present in the course of his work, which raising the forklift mechanically and using two rubber tree stumps to support the heavy horizontal iron bar, did not constitute an unusual danger, as it was an usual risk in the nature of his job, and could reasonably have been foreseen by the plaintiff whilst he was doing his job. To apply all those cases to the incident of the two men who had fallen off a Ferris wheel in Cheras on 11 November 2021, it is important to know whether the fall is something to be expected or foreseen from the two men when they attempted to ride the Ferris wheel. The sentence itself makes one question the logic behind it. That is how unreasonable it is, hence denoting the unusualness of falling off a Ferris wheel. As a customer who attended to ride the Ferris wheel, usually they do not expect that by riding the Ferris wheel, they are most likely to fall. As a reasonable person, they will assume that when the Ferris wheel is open to the public, it means that it is guaranteed safe to ride the Ferris wheel. No one would not have expected such danger to occur at that time, unless there was a warning sign stating there. It is because the logic is if they know the Ferris wheel is dangerous, which would make them fall from it, of course they will not ride it in the first place. To conclude, it can be said that the two men cannot be expected to have prior knowledge that they might fall from the Ferris wheel, and for that reason, the danger are most likely not known to the two men. But if what happened was the two men know and aware that the Ferris wheel is dangerous at the time, but end up riding it anyway, then the management of the funfair cannot be held liable.
Okay, so we have come to the last part of our presentation for today, where we will discuss the fourth problem statement we found in our case that leads us to the fourth sub-issue, which is whether the management had failed to take reasonable care to prevent danger by giving notice about any possible dangers on all of its rights. So the rule is that the occupier had failed. If the occupier had failed to take reasonable care to prevent danger by posting notices or guardians, then the last requirement is proven, and this can make the occupier, in this case the management of the theme park, to be liable. So we refer to the case of Wheat and Lacan and Company Limited 1966, where the claimant stayed in a pub owned by the defendant. However, when the claimant was climbing the narrow and steep steps to get back to his room, he was fatally injured and killed. The steps had poor lighting and also broken handrail. So in this case, it has shown to us that the defendant had failed to take reasonable care to prevent damage from occurring by notice, lighting, guarding, or otherwise, as they had occupational control of the premises, and they are ought to have provided safe premises for people using it. So reasonableness varied from case to case depending upon the facts and circumstances of each case. For example, it is normal to expect that shopkeepers to do regular inspections, but it is unrealistic to expect him to maintain a constant eye on the floor throughout the day if something is broken. So since the first three requirements are assumed to be fulfilled, we will look at the fourth requirement. Applying the case of Wheat and Lacan, the question to be asked in this case of Ferris wheel is whether the management of the theme park had given notice of any possible danger towards their customers. And this includes on the ticket purchased by them at the counter, at the main entrance of the theme park, or even at every right entrance, and in this case, at the Ferris wheel entrance. So the circumstances of a theme park in reasonable human logic, and at that, Ferris wheel is a dangerous one. Therefore, the management has to provide for notice of danger. Thus, users are then advised to be careful in consideration of their own safety while riding it. Additionally, in this situation, the management is expected by any ordinary man that they will provide a safe environment from all kinds of harms, and this includes giving notices. Next question to be asked in this case is whether there were guards hired by the management themselves to look after each ride in the theme park so that they can put all of their focus in controlling the situation at each ride. So for example, if there was a guard at the Ferris wheel section, then they can make sure that the Ferris wheel does not exceed any limit, because this will bring more dangers to other passengers. So in conclusion, two assumptions can be made in this case. Firstly, the management had not put up any notice either on the ticket, at the main entrance, or even at the entrance of the Ferris wheel, and there was also no guard controlling the area. If this was what happened in this case, then the management of the theme park would be liable, as they had failed to act reasonably in avoiding the danger. Secondly, our assumption is that if the management had actually put up the notices either on one of the three mentioned spaces just now, and guard was also present on each ride, then they will not be liable. As a whole conclusion, since our case is still new, we don't really have the full report on what actually happened on that day by any news websites. So if let's say all of our assumptions just now were true, were what had actually happened in this tragedy, then high possibility that the management would be liable under the Occupiers Liability. So that is all from our group. Thank you.